Hello and good afternoon to you all. Thank you so much for joining us for today's webinar on paternity testing and child support. What are my clients' options? My name is Catherine Gorter and I'm the Community Legal Education and Engagement Coordinator at Legal Aid Queensland. Apologies that I am off screen. We just have room size limitations here with the camera, but I'm very grateful you could all join us today. I'm just going to start with an acknowledgement of country. So Legal Aid Queensland acknowledges and respects the First Nations custodians of the land where our offices stand and where we work to help disadvantaged Queenslanders uphold their legal rights in our justice system. We pay respect to their elders, law, custom and creation spirits, and we recognise that these lands have always been places of ceremony, teaching, research and learning, and we acknowledge the important role Aboriginal and Torres Strait Islander peoples play in our community and improving our legal system. So again, welcome to our webinar, Paternity Testing and Child Support, What are my clients' options? Our presenters today, we have Danielle McKibben, family lawyer from the Family Law Services team here at Legal Aid Queensland. We also have John Blaney, who's jumped on screen. He's the principal lawyer from the Family Law Services team as well at Legal Aid Queensland. And lastly, we have Sonia Ryan, who's the paralegal in the same team here at Legal Aid Queensland. Thank you to all three of you for making yourselves available for this webinar. Before we kick off the presentation content today, I've got a little bit of housekeeping to run through with you all. Firstly, this webinar is being recorded and the laws and content are accurate on the day of this live presentation, are subject to change. We will post a copy of this webinar recording on Legal Aid's YouTube channel and we'll send you a link to that after the webinar. If you have any technical or audio issues with this webinar, you will need to contact GoToWebinar customer support for getting that help during the webinar. Unfortunately, I can't help you with that during the live webinar. This webinar is going to run for 1 hour. There'll be about 40 minutes of presentation time and up to 20 minutes of question time. So if you do have questions for the presenters during the webinar, please pop them in the questions section on your screen and I'll see those and we'll ask them at the suitable time. I know that a number of you submitted questions before the webinar when you registered. Thank you for those. And the presenters have included those questions and answers within their presentation content. So thank you again for including those. Sorry, some just popped up on my screen. There is a copy of the PowerPoint slides from today's presentation available to download. You'll see the handout section on your screen. You can get a copy of those. We'll also send a copy of those with the email after the webinar. So we're going to kick off this first poll, wanting to know a little bit about who's joining us today. So the first poll is, what region do you work in? And I'll just launch that for you now so you can pop your answers in. So the first option is South East Queensland, there's Far North Queensland, Regional Queensland and outside of Queensland. So I'll give you about 5 more seconds to pop your answer in there and then I'll share the results with everyone. And just pointing out, this webinar is it aimed at just Queensland law or also federal law?
That's a good question. We mainly just deal with Queensland.
Mainly just Queensland?
But we're up for a challenge.
Yes, and the law we're talking about is a federal law,
okay.
The child support legislation.
Perfect, perfect. All right, I'll close that poll now and just share the results with you all. And so joining us, so we've got 61% of people are from South East Queensland. We've got a few from Far North Queensland, a few from regional and 8% from outside of Queensland. So just, yeah, interesting to know. Thanks everyone for that. And I'll move on to our next slide and our next poll, which is, what is your role? So I'll just launch that one now. So if you can answer this one as well, the options are support worker, financial counsellor and or health education worker, social worker, lawyer or other. And in the last webinar, the other category was very popular, so we'll see what we get today. I'll give you another 5 seconds for that one. At this stage, mostly lawyers, that's interesting. Okay, a couple more seconds. Close that one off and share the results. So we have 82% lawyers attending today and 16% other. So thank you to the lawyers and other frontline workers doing this
Got to
today.
get those CDP points.
Thank you very much. All right, let's click ahead. So I'll now hand over to Danielle to start the presentation content. Thanks, Danielle.
Okay, thank you. So what will we be learning today? So why a client would require parentage testing, the court jurisdiction regarding parentage testing, and how legal aid can assist in regards to parentage testing. So if we can go on to the next slide. So we do want to acknowledge that in relation to terminology, as we all know, it does take some time for legislation to catch up. So both legislation and policies in this area are still use gendered language. So we still refer quite a lot to mother and father. It is anticipated at some point law reform will correct this, especially to acknowledge trans men and non-binary birth parents and trans women and non-binary other parents. So for today's purposes, we may slip into the terminology of mother or father or paying parent or payee parent. So we just wanted to be upfront with that, as well, the legislation and policies are still fairly outdated and hasn't caught up to society's reforms. So if we can move on. So since a majority of the poll we are lawyers, let's start with the law. Under the Child Support Assessment Act, Section 3, it's a fairly common knowledge that a parent has a financial obligation to maintain their children. I won't read the act in its entirety. I trust that she's capable of doing that. But ultimately, at the end of the day, a parent has a financial obligation to maintain their child to the age of 18. There are, of course, extensions beyond that. That's for another webinar. But it does not mean that the financial obligation would put the parents in financial detriment. So there is that responsibility there. However, there are exceptions under the Act as to what maintaining that child would look like. And in our circumstances, it would be child support. So again, the legislation's on the screen. You can feel free to go and read that in your own time. So if we can continue on. So why is parentage testing necessary? These are just a few examples. So there are instances where the father is not on the birth certificate. However that comes about, that might be the father doesn't acknowledge he's the father, or the mother does not want him to sign the birth certificate. The father refuses to sign any documents acknowledging he is the father. So that's not only in relation to the registration of the birth certificate, but any statutory declarations acknowledging he is the father. Circumstances where the father is not the father of the child and wants to stop paying child support. Another instance is where a person has applied for child support and has received a rejection letter from the child support agency. However, that rejection looks like, that letter has still been given. And then Centrelink is going to cut benefits if the person does not pursue child support, and we can go into that a little bit further. So parentage testing, again, back to the law. Under the Family Law Regulations, it sets out the requirements for a legal parentage test. The most common one is DNA typing. That DNA typing does obviously have to be complied with the regulations. So therefore it needs to be in an accredited laboratory for the purpose of carrying out parentage testing procedures. That laboratory does have to be accredited and meet standards. It's not just a matter of plucking a hair and sending it off. There's a lot more to it. The regulations also sets out the collection, storage and testing of samples, and then the reports that must be completed by the person who's carrying out the parentage testing. So that is set out under the regulations, and again, you're more than welcome to go and have a look at those regulations for a more detailed list. Okay, so when it comes to Legal Aid Queensland, we can assist in parentage testing. However, with most government organisations, we have rules and guidelines and policies that we have to comply by. So when seeking a grant of aid, it is for the reasons of opposing a finding of paternity by the court, or to seek an order for parenting testing if no other appropriate service can assist, either party denies the child's father, so that's mum denies or father denies the parentage of the child, whether the male's whereabouts are known, and if there is a good reason to believe the other party has capacity to pay child support or child maintenance, as the case may be for the child. Basically, we need to remember that Legal Aid is a government-funded non-profit organisation. We're using taxpayers' money. We need to justify the parentage testing. If it doesn't meet that criteria, it may mean that a grant of legal aid will not be available. However, we are up for a challenge. We would happily try and find a way to assist if it doesn't meet the guidelines, or make referrals to other services that may be able to assist. So if we can go on to the next slide. So this is just a continuation. So if the male applicant denies being the father, so dad saying, I'm not dad, legal aid cannot assist unless there's an adequate reason provided to support the denial and agreement to submit to parentage testing. So it's not just a matter of, I'm not dad, I'm not paying child support. It doesn't work like that. We need a more reliable, more legitimate reason why he should not be paying child support and why he needs to submit to this testing. A good example of this is one that I've had recently, where the father was incarcerated. A domestic violence order was applied for once he was released, and in that domestic violence application, it clearly outlined, the mother lodged the application and it clearly outlined he is not the biological father of this child. So with that and his legal aid application, we were able to assist to support the denial, and he agreed to testing, and then he found out he was not the father, and then so the battle was to get some money back from Child Support Agency. So that's the best way I can kind of put a real life example in relation to that guideline. Assistance can only be provided if the finding relates to a determination of the substantive proceeding. We are not Maury Povich. We don't parentage test for the entertainment. We need to parentage test and then follow up with a substantive law proceeding. So we need an order for child support for child support to be paid. We need an order for child support payments to stop. That's when we can provide that assistance. And then assistance for parentage testing should only be made on the condition that an order from the court seeking costs for the testing, unless the other party is also in receipt of a grant of legal aid. So once again, we are using taxpayers' money to cover the costs for this parentage testing. We do ask the other party to cover the costs, and Sonia will speak to this more in our further slide. Okay, so parentage testing for female applicants. So this criteria must be satisfied for legal aid to be granted for a female applicant to attempt to resolve proof of parentage for child support matters. So I'm not going to go too much into this, but I'll just briefly go through them. So the means test, obviously, again, taxpayers' money. If they have the ability to do it themselves, we won't be able to assist. The applicant meets the guidelines of paternity, which we will just be discussing shortly. There's a maximum of 2 putative fathers. So we will ask for 2. We are not in a position to test multiple people, so we would ask the client to give us the most likely 2 who may be the father. The putative father is not serving a jail sentence exceeding 12 months unless it excludes the other person being the father, and it's most likely a successful prosecution of a second male. So to explain that a bit better, the reason why we don't do paternity tests for for males serving a jail sentence exceeding 12 months is because they're in jail, they're not likely getting an income. Even if we were successful, they would be unable to pay child support anyway. And then the reason why we would if it excludes another person, is that obviously then that the female would be able to get child support from that second person. The logistics of trying to get paternity testing in prisons can be a bit difficult, not impossible, but that's also another factor that needs to be considered. So proof of parentage is needed to claim child support. So again, it's not just the sake of just getting a DNA test, it's the test needs to be done to claim child support, and that no legal presumptions of paternity exist. Again, we'll go through those presumptions in a minute. And then the applicant meets the merit test. So the likely outcome of that substantive matter being in their favour. Okay, so then we're going to move on to, we're going to continue. So applicants seeking a grant of aid should forward all the following for assessments. This is very similar for both males and females. So we need a completed and signed legal aid form. That might sound a bit obvious, but you will be surprised how many people don't think that they need to complete it. A proof of income and assets, so that refers to the means test. So if they are on a Centrelink benefit, we would need a copy of that. If they are working and if that's on a part-time basis, we would need copies of their bank account statements or their pay slips. And then if applying for child support and that's been rejected for whatever reason from the child support agency, we would need a copy of that rejection letter as well. Okay, so on the flip side for males, so again, similar in relation to the means tests and the paternity guidelines. However, the male applicant has been assessed by the child support agency to pay child support for the child. So in this regard, it means that the father has been paying child support, has been assessed by paying child support, but he feels he shouldn't be paying child support because of whatever reason, and he would provide that evidence and that reason. Again, not serving a jail sentence exceeding 12 months. The child is not 18 years of age or older. Again, there is exceptions to that, but that's another webinar. And the applicant meets the merits test. So again, it needs to have some prospects of succeeding so we can do the parentage testing for that male applicant. Okay. Again, they need a completed legal aid form. So this is the male applicants, completed legal aid form, proof of income and assets. So again, Centrelink, pay slips, bank account statements, and then copies of any relevant documentation. So going back from the example that I used previously about the domestic violence order, that was a copy of relevant documentation. If there's text messages, you are not the father, or anything in that regard, that needs to be provided along with the legal aid application. So then it can be assessed and a grant of aid can be considered. Okay, so legal presumptions of paternity. So you are automatically dad if it's a child of a marriage under section 69. I won't go through any more of the sections. I'll just read them out and you can go back and look into a bit more detail afterwards. So the next one is cohabitation not before 44 weeks and not earlier than 20 weeks before birth. So we have noted that there is difficulties actually proving this. Ideally, when you announce the pregnancy, it's all about gender reveals and baby showers. We're not actually focusing on, I need evidence in case I need to claim child support at the later date. So this can be difficult to provide evidence on. It's not something that we entirely rely on, but we just put it there. So that is a legal presumption. Obviously, the birth registration, the birth certificate, if dad signed the birth certificate and it's black and white, wet ink, it's going to be hard to dispute. A legal presumption finding of a court. So we've gone through the court process. The judge has actually said, nope, you are dad. That's a legal presumption. And then a sworn or affirmed acknowledgement. So a stat dec or the new child support agency form saying that, you know, he is father and he has signed it and acknowledged that. So they are our legal presumptions of paternity. Okay, so when we get our legal aid application and we're off to court waiting for 3 hours to be listed on, what can the court actually do? So again, I'm not going to go through the sections, but under the Family Law Act, they can obviously rebut a legal presumption, and that's what we would be wanting to do. They can declare parentage. So dad, you are the dad. So Maury Povich, but in a black robe from the bench. And then obviously a signed order confirming that. They can order parentage testing. So if a party refuses to parentage test, and 9 times out of 10 it is dad, then they can order that parent actually go off and get tested. And then they can order a person be liable for the costs of a child. So the DNA testing has been done, you are dad, here's an order, go to child support agency, you have to pay child support. And then the flip side of that is an order that a person not be assessed liable for costs of a child. So dad's been paying child support for 8 years, finds out that he's not dad, that order allows him to go to child support and say, hey, I'm no longer liable to pay costs for this child. And can I have some money back? So that's the powers of the court. So again, go have a look at those sections if you want to a bit more detail in relation to that. Okay, so what we do, I'm going to hand over to Sonia because this is her area of expertise.
Okay, so we've got the grant of legal aid. I'll ring the client and I obtain their instructions, and I get a detail as to why they say this person's the father, what the history has been of the relationship, and again, if there's potentially 2 fathers, who might be the father. If they don't know where that putative father resides, then we do a location questionnaire with the client, and we ask for a location report to be done. This is done through a private agency. They quite often, about 80% of the time, they can generally find where this person resides, and often discover phone numbers, email addresses. They go through things like rent rolls. There's somewhere that they can find those details, and then if we've got the address, then we write to the person. We say, you know, we think you're the father, either agree to sign a statutory declaration, or if you are disputing that you are the father, then please agree to do an acknowledgement of debt and undertaking to do the DNA test. Now, the Legal Aid have an agreement with a private agency that we do these through, and it's for a discounted amount. The first step is that Legal Aid will pay those costs, but if they are found to be the father, that's what the acknowledgement of debt and undertaking is, that we then ask that person to pay the cost of that. But in the first instance, Legal Aid will pay for that. If they agree, that's all well and good, we'll make those arrangements, and the results are normally back in with about 6 to 8 weeks. If they ignore our correspondence and think that we're just going to go away, we don't. So then we will take the steps of having to go to court. If we go to court, we often rely on things like to prove the relationship, and they often have what Danny referred to earlier was their text messages, everything like that. So, and we attach those copies of those text messages to their affidavit. If we still can't find an address where this person resides so that they can be personally served, we seek an order from the court for substituted service. And these can cover things like if they have a Facebook account, we can seek an order for them to be served on their Facebook or Messenger. If we can prove that we've spoken to that person on the phone, we can seek an order for them to have substituted service by phone, email, or in some circumstance, and often the case, they still live with their mum and dad, and we can seek an order that we can serve the parents in that regard.
No judgment there.
No judgment. So that's the steps that we get if we have to go to court, and it is often about 50% of the time they might agree before we go to court, or 50% of the time we have to go to court. With the first call over, if they've been served, we ask the court for orders for DNA parentage testing. That's then served on them, whether they appear in court or not appear in court. Again, a lot of them choose not to even do the DNA testing, and then the court will take the view that if a man had been told that he was the father of a child and they disputed it, they would go do that DNA testing. And the court will take the view of the fact that they didn't do the DNA test, they must realise that they're the father, and they will make default orders declaring him the father. And that's the process that we have been doing. And the reason that we do reach out is that we can't start this process until the baby has been born and they've approached the child support to obtain that letter of rejection. Legal Aid need that letter of rejection to be able to start the process. So once they've Bub's been born and they've made that application, they've got that letter of rejection, we can apply. And we have been strongly encouraging mums to do this at this early stage, because it is often the case they're only in receipt of Centrelink benefit at that stage, because they are at home looking after Bub. They would meet the means of the merit test then if their sole income is the Centrelink income, and they don't have substantial assets, obviously. So it is encouraged that they do it at the step, because once they go back to work, then that's the difficulty, is that they're earning wages and it's likely that they'll be means tested out. Okay, that's all my part. Back to Danny.
And so another important thing to factor in is that child support agency will not just accept a DNA test. You need to have that order, so to advise that you are the father or you're not the father, for then child support agency to stop stop collecting child support. So a DNA test alone is not going to cut it. You need that order, and that's why we do this process. Okay, so we understand that giving birth and single mums and that have it hard, and we do understand it's a difficult time in their lives. So what we do is we utilise a safety first and trauma informed practice model. We try and utilise the consistency approach, so they are only speaking to one person and not having to retell their story multiple times. We can assist with parentage testing in a safe manner and not disclose information to the other party, particularly if the cause of it is domestic violence related. Our main priority would be in the best interest of mum, which is a flow-on effect in the best interest of Bob to keep them safe. So our support workers in-house, and we do refer sometimes outside our services as well. And the solicitors, we're all experienced in handling high-risk matters. I don't need to tell you guys this. You're a majority of lawyers anyway. You're probably implementing that, but we just wanted to let you know as well that when we're dealing with parentage matters, we do this in a sensitive way, and we handle these high-risk matters on a regular basis. For the safety, for the social workers out there or anyone out there who's dealing with these clients on an emotional level, we can also support in any safety plans that are put in place to protect the mother and the child. So that's just a bit of how we manage safety in-house. Okay, so how can Legal Aid help? So we, in regards to the child support space, we have a child support clinic that runs on a weekly basis. So we can accept referrals in, and we can provide that telephone advice over the phone. We can offer minor assistance, which means a grant of aid to the means and merits test for parentage testing. So, the parentage testing itself, we can try and assist with negotiations on, birth certificates, whether the father should be taken off the birth certificate. Can that be done in a more consensual, collaborative approach? We do legal representation at court. We attend a child support call over. So all of the matters are listed at once. We attend to that and assist the court in that regard. And then we can accept referrals from community legal service centres, private firms. If you have a child support query that you're not sure about, you want to refer it in, or you just need some guidance, we can provide you with that assistance. Okay. So referrals, this is where we are trying with webinars like this to receive referrals from external services. So we are asking hospitals, mum and bobs groups, anyone who feels that this service will be productive for them to email or call Legal Aid Queensland. We can accept referrals from external services. Once we have a referral, it doesn't necessarily need to be in a form. It can just be an email with the details of the person that's needing that assistance. So parties and children's names and date of birth, if the matter is next in court, and if so, when, details of the issue and the urgency. My Centrelink benefits are going to be cut if I don't pursue child support. I need help, that kind of thing. This might sound obvious, but contact details for the client, the amount of times we actually get referrals and we've got no way of contacting the client, and the safety measures as to, is the number safe to call? Can we leave a voicemail? Would they prefer a text before calling? And if the client has any added vulnerabilities, culturally or linguistically diverse, do they need an interpreter? We can make those arrangements and accept that referral. We love self-referral clients. They can call us on the information line saying we need some help with child support, or they can attend a legal aid office, or just by submitting a completed legal aid form with the supporting documents that we discussed earlier. So yes, if you're out and about, or if you have contacts that you think that, oh, this will be perfect for legal aid to assist with parentage matters, please feel free to reach out and make those referrals into us. We need more files. Okay, so on your screen is just our resources and contact information. So we do have a wide variety of child support booklets and frequently asked question brochures. Everyone should be able to know the legal aid application form, Google it, download it, save it to your desktop, comes in handy. And then is the contact details of myself, Sonia, and John. We also have Georgia, who is a very lovely, experienced lawyer in this department as well. So feel free to reach out to one of us, all of us. We're here to assist. So those are our details, and you'll have those when the slides are distributed.
Yes, one other thing I just should add, John here, sorry, is at the moment, Georgia is the principal lawyer of the team, and I'm in another role. This is my permanent job, but at the moment, Georgia is the boss. Feel free to contact Georgia or Sonia or Danny, or when I'm back myself. We're always more than happy to help. There's a lot of vulnerable clients out there, particularly young mums who have been told by Centrelink, if you don't apply for child support, we're going to cut your benefits off. They're given a short period of time to prove that they're taking reasonable steps to get child support, and they don't have a lot of support or help, and they've got no idea where to go. That's why we've been doing this awareness raising, information sharing, because there's this whole group out there, mostly of young mums, who are getting their benefits cut off or reduced because they don't know where to turn.
Thanks, John.
Thanks,
Okay.
Well, we've whipped through that conference.
Very quickly.
So, which is great. So we've got stacks of time for questions. So as I said earlier, there's a question section on your screen. Feel free to type a question in now, and we can ask that of the presenters while they're here in the room.
We should add also there's exemptions as well. So if Centrelink have said that they need to take these steps, if there's any risk of DV as well, they have DV orders and they've spoken to us about it, and we consider that they are at risk and there is genuine concerns there, we can give them a letter to Centrelink for an exemption, that this process not be followed.
Right. Well, while we're waiting for questions, I'm going to. Oh,
sorry, I just wanted to add. Just recently, we did one of this, and a question arose, which I think is a really good one. Is that what happens if the father was to pass away, and what happens to the child support debt then? So, our understanding that that will become a matter of the estate, and that's something that legal aid doesn't deal with. So if that pops up, sorry, that's the one thing we can't help you with.
Okay. Well, while we wait to see if anyone watching has any questions, I'll just skip ahead. We've just got a couple of summary slides, and then we'll keep an eye out for any questions that come through. So please feel free to ask. But I'll just jump ahead to the next slide. So this slide has our key phone numbers to get in touch with legal aid. So the first one, our legal information line, is the 1300 65 1188. That's our key phone line. So for people who've got any type of legal issue, wanting advice, wanting legal information, call that, and anyone can access free legal information by calling that phone number. And that's the one that Danielle mentioned earlier. We also have a priority phone line for Aboriginal and Torres Strait Islander people, and that is the 1300 65 0143 phone line. So anyone calling that phone line will be answered as a priority in our call queue. So we encourage you to forward that phone number onto any clients, or if you're supporting any clients who are of First Nations background. The third phone number there is for anyone who has already submitted an application for aid with Legal Aid Queensland and is wanting to check the status of that or have any further questions. So that's the 1300 383 900 phone line, and all of these phone numbers are also listed on our website. On the Legal Aid website, there are heaps and heaps, actually probably over 80 free legal information publications on a wide range of legal issues. So things like going to court, young people in the law, domestic violence, debt and credit issues, problems with legal issues after a natural disaster. We've got a huge range of publications there that you can download and print, or you can order them for free with free delivery to be delivered to your organisation to hand out to clients. So please do take advantage of these resources and order as many as you need. Get online and have a look at what we've got available. There's heaps of really great new publications there as well. And the last slide today was to talk about our next webinar, which is penciled in for the 28th of May at 1 o'clock. And that is going to be on domestic and family violence pathways to safety. And that will feature our referral pathways officer and a lawyer from our violence prevention and women's advocacy team talking about the referral pathways arrangements we have here at Legal Aid. And I've just noticed the questions come through, so I'm just going to pop back to our questions slide. Okay, actually it's more of a comment. This isn't a question, but just mentioning that we had a matter recently where the father didn't deny paternity, but wanted nothing to do with the child and refused to do the DNA test or sign the birth certificate. We were able to obtain a declaration of parentage in that matter.
Yeah, that's a very common thing that comes through the child support clinic. A lot of people seem to associate child support with spending time with the child. So we do provide the advice that that is two separate things. And what we aim to do is, if there is any associated family law matters, we can assist with that as well. So we all know that matters when it comes to children and families, a lot of the DV space, the child support space and the family law space kind of collide. So, obviously paternity is a starting point, which will have a flow-on effect in relation to family law matters. So if the parentage testing is done first, and then it's a question of dad saying, okay, I am now dad, I want to spend time with this child, then we can give advice and go down the family law space. So yes, it does seem to, a lot of fathers in particular automatically assume that I'm paying child support, I have an automatic right to see the child. We do give advice that is two separate issues, but that does happen quite a lot.
Thank you. We've had a question come through that is relating to a specific client situation. So I'll ask the question, if this is something that you need to follow up individually with this worker afterwards, then we'll do that. But this person has said, I have a client who wants to apply for parenting orders. However, mum is saying he's not the father. Will LAQ fund a DNA test prior to commencing proceedings, or should we apply for funding for FDRC and let her raise that issue at that stage?
Well, I mean, whichever direction you go, paternity is always going to be the question. So I think it would be the question would be, why is mum denying dad being the father? So what's the is there an actual reason for the denial? If there is, then we could do the parentage testing under a grant of aid, and then on the conclusion of that parentage testing, family law orders can proceed. We can ask for further grant of aid to go down the family law road. If you want to go straight to mediation or FDRC, and mediation does occur and then a parenting plan or agreement is made, and then later on down the track paternity is still questioned, the family court's not going to be minded to make any orders if there's any doubt about paternity. It would be an issue that could be raised. Whether that would affect family court orders, it would be hard to say, not knowing all of the information. I think in circumstances where this occurs, it's quite easy to get overwhelmed and try and think of what path to take. I think the best place would be to start is dad actually dad? Get that confirmed first, and then start along the mediation road and then the family court if needed. So if there's a legitimate reason why either party is denying the paternity of the child, which would lead to the court making an order that they are liable or they're not liable, then submit the legal aid application, produce that evidence, it can be assessed and a grant of aid could be made.
There's just something I should add to that. It's something that's come up with conferencing over the course of many years, and they now have a specific policy about it. You apply for legal aid. If the other party also applies for legal aid for the mediation, when they get the client assessment sheet and the invitation to attend mediation, a legal aid form's always sent by conferencing. If they also get, as part of the other party's response, oh, but he's not the father, now that triggers conferencing, referring to grants to see if they should fund a DNA test before proceeding with the conference. And that would be a consent DNA test if both parents are willing to participate. So there's definitely apply for legal aid for a conference, because there's now a pathway built into our policies that deals with that.
So then the DNA test can occur, and then if we definitely know that both parties are parents, then mediation can occur, and then filing that go down the family court road. Thanks, John.
That's okay. Yeah, that's just very recent.
Okay, that's why I didn't know. I don't feel bad now.
I was just going to jump in and say just that webinar I mentioned for next month, the one on pathways to safety and domestic and family violence. We will start promoting that probably early next week, and we'll have that on the webinar section of the Legal Aid Queensland homepage. And if you are on our mailing list to get updates on upcoming webinars, you'll hear about that next week as well. We have had another question. Again, not sure if this is something you can answer, so throw it back if there's something you need to follow up with the person. Someone said, what if the father is not the father, but the actual uncle?
We can test two putative fathers.
Yes.
Because I guess that's probably one to follow up about whatever.
It'd take the same path though.
It would take
the same path though. If they're saying that the uncle is, then it's the uncle that we would be sending the correspondence to.
Okay.
So there has to be
to get
the DNA test results being that 98 point whatever it is %.
99.
Yeah, 99. Sorry, 99 point whatever it is that comes back in the DNA test.
Yes.
For there to be two people that would satisfy that, just being someone's brother isn't enough. They have to be identical, not fraternal twins. So if they are identical twins, then they need to raise that at a very early time. But even most twins aren't identical, they're fraternal twins. The situation you're describing wouldn't come up as a problem with the DNA test very often.
Thanks, John.
And we should note that when it is DNA testing, it's not just the dad and the child that gets tested. It's mum as well. So they do both parents to get that percentage.
Okay, well, we do have time for more questions if anyone has any question they want to ask about presenters. That's pretty much all of our content today. So if nothing comes through in the next couple of seconds, we might wrap this one up. So, okay, thank you everyone for joining us. Really appreciate you making the time to attend today. As I said earlier, we will send a copy of the webinar recording link with the PowerPoint slides attached shortly. And we hope you join us for the next one. And thank you again to our presenters, Danielle, Sonia, and John for popping in. And yeah, we hope, oh, actually, we've had one.
Another question.
Last question has snuck through. Sorry, while I was wrapping up. Do you need a Section 60I to apply to court for a paternity order?
No.
No, okay, quick answer.
That's an easy one. No.
All right, on that note, I'll continue wrapping up. Thank you again, everyone, and hopefully we'll see you at the next webinar. Bye-bye.